Ladies and gentlemen, welcome to Civil Justice Subcommittee for February the 7th, 2023. Madam Clerk, please take the roll.
Representatives Beck. Here. Beluso.
Here.
Beluso, my apologies. Capley. Eldridge. Here. Farmer. Here. Grills. He was in the hallway. Do you want me to? He went to another committee. Okay. Lamberth. Parkinson. Todd. Here. Chairman Russell.
Here. I'd like to first start off by thanking Speaker Sexton for allowing me to serve as chairman again on this wonderful committee. And rather than going over the policies and procedures, we had emailed those earlier. So if anybody's got any questions, we'll go over that now. And not seeing any, does anybody have any personal orders? Chairman Farmer, you got anything? Okay, just making sure. All right, I want to introduce some of the people on our committee today, and my legislative assistant, TJ Sutton, research analysis, Courtney Kaufman, attorneys Elizabeth and Sonia, I hope I got that right, Tanya Overton. Two interns in my offices are Abby O'Dole and committee intern Cherie Gupta. Where are they at?
She's in the corner.
And then, of course, we got a return of last year's intern, Mac. He's out there in the thing. I don't know if Farmer's seen him. Clerk Emily Johnson and Sergeant at Arms Tommy Woodward. Good to see y'all here today. We've got 5 bills on the calendar for today, and before we jump into that, I want to make sure that we note that we rolled item number 3, House Bill 187, without objection, will be rolled 2 weeks. So starting off today will be House Bill 418, item number 1 by Representative Stevens. Motion. We got a motion and a second. Representative Stevens, you are recognized. Make sure your microphone's on. It's a little button there that's got the...
Okay, it's had the red light on. So thank you, Mr. Chair, members of the committee. House Bill 418 was brought by the Administrative Office of the Courts. It's a straight repeal bill intended to remove TCA 17-2-121. This statute is not needed. It conflicts with current Supreme Court policies and procedures for interchange and designation of judges. The statute that we're asking to repeal allows for parties in a civil case to hire a retired or former judge to preside over a trial if there is a backlog or the case is very complex. To our knowledge, the statute has never even been used.
And do we have any questions for Representative Stevens? Is this your first bill?
Yes, sir.
Oh, wow. We sure we don't have any questions for Representative Stevens? All right, Representative Todd.
Thank you, Mr. Chairman. So this statute that we have on the books allows for a retired judge to be hired by, I guess, attorneys in a case or participants in a case. What's the going price for a retired judge?
Well, I'm not sure. This has never been used that we know of, but
Representative Todd, you recognized.
So do you know any judges that are on a list that you could hire?
Representative Stevens.
Thank you, Mr. Chairman. I have never heard of this statute. I'm in my 14th year of practicing law. I think most of the attorneys that I've talked to up here didn't know this was a law either.
So you're just practicing law. So when do you get to the point where you're actually working?
Well,
Representative Stevens.
we work hard. Attorneys work very hard. I always tell folks when they want to make fun of the attorneys that the next time they're at a jam, they can call their comedian. So,
Representative Todd, you're recognized.
so
Thank you, Mr. Chairman.
Thank you. And not seeing any further questions, we're fixing to, questions been called, and I don't know what you've been doing for the last 14 years, but we're going to vote on it. So all those in favor signify by saying aye. Aye. All those opposed signify by saying no. Ayes have it. Congratulations, full civil.
thank you.
All right, next up is item number 2, House Bill 249 by Chairman Farmer.
Yes, thank you, Mr. Chair.
We got a motion and a second.
And don't hold this against me, but I'm carrying this for Leader Lamberth.
Uh-oh.
This afternoon, I guess. Yep. Members, what this does is, Leader Lambert's brought a bill. When you file a detainer action, that's an action to evict someone from a property for whatever, breach of contract, failure to pay, XYZ, right? So go to court, and yes, let the court know what's going on, tell them they breached the contract, and whatever way. The court will then give you possession of the property. They'll award you money, judgments, whatever, right? Whatever you need. So generally, go in, let the court know what's going on, and they will, by default, if the person's not there, whatever, breach contract. So the judge says, okay, Mr. Farmer, I want to give you, your client, this possession of this property, a money judgment, this amount. And a lot of times I'll say, well, can we reserve damages? We go on the property, inspect it, and they'll reserve that for a later date if something's messed up inside the home, right? So the court will award possession, and they'll wait 10 days to issue what's called a writ of possession. That means you can actually go in and take possession of your property, your rental home or something. And that 10 days is a appeal period for somebody to come in and post an appeal of something they think the court's done something wrong. So what this bill does is allows for the attorney to come in and say, Judge, I want that writ of possession to be issued within 2 days instead of waiting the 10 days. Because a lot of times they'll wait that 10 days. You'll have to come back, and your client will have to pay more money, take more time to get that actual writ of possession issued. Actually, in East Tennessee, our judges will go ahead and issue that writ on the day of the judgment. So you don't have to come back. So they'll say, you know what, we're going to issue the writ, but you can't go get it. It don't become effective until day 10, right? So you don't have to come back, don't have to waste any more time, whatever, right? But this bill says you got to wait 2 days before the writ can be issued, and instead of waiting that 10 days. So this adds more time, more costs, XYZ. So that's what the bill does. It kind of decreases the time. You still got your appeal period, but the courts can go ahead and issue that writ within 2 days instead of 10. So.
Very good. Any questions for Chairman Farmer? Representative Parkinson.
Thank you, Mr. Chair. So just so I'm clear, the writ will be issued in 2 days versus 10 days right now. But the people in your district, they issue it on the day of, right?
Yeah. Excuse me.
Representative Farmer.
Thank you, Mr. Chairman. When I go in, and I'm representing the landlord, and I'll go ahead and ask the court for the judgment. A lot of times, folks just don't show up. Majority of the time, it's by default. But when they do, if once they've been heard and due process and all that jazz is done, the court will go ahead and say, you know what, I'm going to issue, get your money judgment, whatever, and then I'm going to issue you the writ of possession, but it won't become effective until that 10th day. So you do it on day one. So, and what we're planning to do is bring an amendment that would make that, we're going to take this 2-day thing out, but it was substantive to the bill today. So next week I plan to bring an amendment, or Leader Lambert's will, to make it just effective statewide to where you can go ahead and the court shall issue that writ on the day of the judgment, with the judgment. But that doesn't, it's not going to take away the 10 days. So you're going to have your 10 days. But the writ will go down, and on a judgment, judges put, writ to be issued, it's the 14th day on the 24th of February, for example.
Okay.
Representative Parkinson, got anything further?
Well, yeah, I do. I think I do. So are we going to be doing amendments in full committee now, in this committee?
Yeah, I'm going to bring an amendment, and the committee will then vote on whether or not to bring that amendment in front of the committee in full.
I'm okay with that.
Right.
I mean, I'm just.
I'd love to do it right now, to be completely honest with you, but I think that it may be substantive to the bill, so I think it'd be inappropriate to bring it in the subcommittee as an oral amendment.
You recognize.
Thank you, Mr. Chair, and thank you for that, Chairman. But is going from 2 days to 1 day substantive?
No. It depends how you look at it. I think, with regards to the law and the policy behind the law, the policy is to give the 10-day appeal period. We're not changing that at all. All it would be is just making it uniform across the state, saying that a judge shall issue the writ upon, at the same time, upon the issuance of the judgment. So just make it clear for everyone.
Representative Parkinson.
And when that writ is issued, let's say if it's issued the same day, right? That tenant can still stay in the property through the appeal process.
That's
right?
correct. They have that 10 days.
Right.
Absolutely.
They have
We're
that 10 days. Right.
Not changing that.
So I don't see that as a substantive change to go. I don't know why we wouldn't make that adjustment here.
Well, it was the call of the chair, and
right.
I said
okay.
that since it's
Gotcha.
not we need to wait.
I got you. Okay. Thank you, Mr. Chair, and thank you for
you.
that.
Anybody else? Chairman Todd.
Just point of order, do we have a motion on this bill already? Okay, thank you. I missed that part. I want to make sure.
And a second.
Sure, thanks.
And have you been practicing more than 14 years?
A little bit more.
Okay.
I
And
think
you've
it'll be
heard-
15 in May.
And you've heard about this before, right?
I have.
Okay. Not seeing any other questions. We're going to be voting on House Bill 249. All those in favor signify by saying aye. Aye. Opposed, no. Ayes have it. Congratulations, full civil. Next up, item number 4, House Bill 39 by Representative Bozo. We got a motion and a second. Representative Bozo, you're recognized.
Thank you, Mr. Chairman. This is a bill that seeks to clarify the costs that are recoverable to a successful appellant in a case brought in our Court of Appeals or in the Supreme Court. The idea for this bill actually originated with our own Tennessee Supreme Court, which, as all of you know, is vested with the judicial power of our state under Article 6 of our state constitution. And it's a little technical, but I think the best way to explain it is just to explain how it came to be an issue before the Supreme Court. In Jackson, Tennessee, a few years ago in 2018, there was a trial, and a jury in a case brought by a company called Milan Express awarded a judgment of $30 million against a trucking manufacturer named Navistar out of Lisle, Illinois, just outside of Chicago. $10 million of that judgment was compensatory damages. $20 million of that judgment was punitive damages. The case involved a sale of approximately 200 tractor trailers. And the jury ultimately found that at a dinner, a steak dinner in Jackson, Tennessee, that the seller of the trucks allegedly made representations as to the performance of the trucks, which the truck manufacturer failed to comply with. Well, after the jury returned this verdict for $30 million, the defendant, the truck manufacturer, Navistar, actually came to our firm and asked us to appeal the $30 million judgment to the Tennessee Court of Appeals. One of the things that we noticed right away when we were retained was that the trial judge made an error. The trial judge never should have submitted the case to a jury because the claim that was being asserted was actually barred by something called the economic loss doctrine. And so we appealed to the Tennessee Court of Appeals on the basis that the trial court had made an error, the entire verdict should be set aside, and judgment should be entered in favor of the trucking manufacturer. Now, when you take an appeal, that does not automatically keep a successful plaintiff from executing a judgment, that is, acting to seize assets of the defendant to satisfy the judgment. Here, the judgment was substantial. It was $30 million, 10 of which was compensatory, 20 million of which was punitive. So on behalf of the defendant truck manufacturer, we obtained a bond to stay execution, that is, to stop the plaintiff from being able to take the defendant's assets while the case was pending on appeal. The bond was very expensive because of the size of the judgment. The premium for the bond for the 3.5 years that the case was on appeal totaled about $136,000. But the bonding company wouldn't issue the bond unless the defendant actually posted security. Because if you are a bonding company and the judgment is upheld, the plaintiff will come and simply ask you to pay the amount of the bond. So bonding companies in cases of this nature, where you have the size of judgment of this nature, will require a defendant to post collateral. Here, that was also very expensive because in order to secure the bond, the defendant had to purchase a letter of credit and have that letter of credit in place for the entire period of the appeal of about 3.5 years. The costs of the letter of credit were approximately $1.36 million. So we had, among other costs that were incurred, $136,000 for the bond premium, $1.36 million, for the letter of credit. So we're off and running. We get to the Court of Appeals, and the Court of Appeals agrees that the trial judge made a mistake. The Court of Appeals ruled that, in fact, the case never should have been submitted to the jury, also agreed that judgment should be entered in favor of the defendant pursuant to this thing called the economic loss doctrine. The Court of Appeals also required that the plaintiff pay the costs that the defendant incurred on appeal, which would include the cost of the bond. Obviously, the plaintiff, Milan Express, was not happy with the result in the Court of Appeals, so it appealed the case to the Tennessee Supreme Court. The Tennessee Supreme Court issued, after oral argument, an extensive opinion clarifying in Tennessee the law with regard to this thing called the economic loss doctrine, and it agreed with the Court of Appeals and with the defendant that the trial judge made a mistake. The case never should have been submitted to the jury, and so the Supreme Court affirmed the Court of Appeals ruling that the jury verdict was set aside and judgment was entered in favor of the defendant. The Court of Appeals also required that the plaintiff pay the costs of appeal pursuant to Rule 40 of our Tennessee Rules of Appellate Procedure. This is where things get very interesting. So once the case was concluded, thank you, Representative Parkinson. Once the case was concluded in the Supreme Court, we, on behalf of the defendant, filed an application for costs with the Supreme Court clerk, which is the procedure one follows to recover costs on appeal. The clerk, Mr. Hibner, agreed that under the rule, the $136,000 that was paid to the bonding company as bond premium was recoverable, and that the plaintiff had to pay that. But the clerk also ruled that the cost the defendant incurred to its lender for the letter of credit, the $1.36 million, was not recoverable. In our view, that was an error in reading Rule 40 of the Rules of Appellate Procedure. So we objected to the clerk's determination that only the bond premium was recoverable as a cost of appeal. And we filed that objection with the Tennessee Supreme Court. And once again, the Tennessee Supreme Court said, you are correct, Mr. Bulso. In fact, the clerk should have awarded both the bond premium and the cost of a letter of credit because both of those components were necessarily incurred as costs in connection with the prosecution of the appeal. And so the Supreme Court entered judgment in favor of the truck manufacturer against the plaintiff in the amount of all recoverable costs. Once the case was over, the Supreme Court asked us through the Advisory Commission on the Rules of Practice and Procedure to clarify Rule 40 so that this misunderstanding that the clerk had with regard to the scope of Rule 40 and the recoverable costs on appeal was not made again. Interestingly, when we submitted the issue to a subcommittee of the Advisory Commission on the Rules of Practice and Procedure, the subcommittee decided not to alter the rule, just to leave it the way it is, despite the fact that the Supreme Court wanted clarity with regard to the rule. And so we have brought this bill before this honorable committee this morning, in fact, to go ahead and simply clarify that when a successful litigant on appeal incurs costs for a bond, whether it's a bond premium or the cost of a letter of credit or other collateral, all of those costs that are necessarily incurred in connection with the prosecution of appeal will be recoverable. And that's the effect of this bill, Mr. Chairman.
Thank you, Representative Bozo. Any questions? And just to clarify, this is your first bill?
It is.
Okay.
Yes, Mr. Chairman.
Great. Any questions? Chairman Todd.
Just a statement. I would be really, really stupid to ask him a question right now.
That's what I was thinking for myself, too. Representative Parkinson.
Thank you, Mr. Chair. And after that, I feel like I'm ready for the bar. So, thank you.
Chairman Farmer. Question's been called. All those in favor of sending House Bill 39 to Civil Justice Full signify by saying aye.
Aye.
Opposed, no. Congratulations. Ayes have it. Civil Full. Next up is item number 5. House Joint Resolution 38 by Representative Reedy. We got a motion and a second. Representative Reedy, you are recognized.
Well, Mr. Chairman, I am not a lawyer or a doctor, but I think with Representative Bolso, if I need a lawyer, sir, I'm coming to see you. But House Joint 38 is a recommendation for a constitutional amendment, and I appreciate the state of Tennessee that we have the ability to change our Constitution when it's found necessary. And of course, the election that we just went through, yes, I was an enlisted soldier, later a commissioned officer. Yes, I did take the oath to protect and to defend our Constitution. And upon becoming a citizen of Tennessee, reading through our state's Constitution, I started scratching my head and understanding the process upon becoming elected. And of course, the last 4 years were spent with Senator Mark Pody, and in that discussion was, do ministers have the right to serve where you're serving, both in the House and the Senate? And we found out that it was deemed unconstitutional. So then that got me, we got that passed, it was on the ballot, and we took care of that issue in the state in cleaning up our Constitution. But another issue was the Section 26, and I appreciate your patience. I've got 2 pages that I want to read that leads up and gives you some history behind our Constitution if you're not aware of those few years that it actually changed under a delegation, okay? The first Constitution of the state of Tennessee was adopted in 1796. The Constitution was drafted in Knoxville by a convention consisting of 55 delegates. Once it was completed, the delegates sent the Constitution to Washington City for review by Congress before it adjourned. President Washington signed the bill giving Tennessee immediate statehood on June 1st, 1796. Most of the provisions regarding declaration on rights, taxes, and legislative authority were drawn from the North Carolina and Pennsylvania Constitution. So I knew we had to get some idea of where we were going to go in the formation of Tennessee. Article 1, Section 26 had read at that time that the free men of this state have a right to keep and bear arms for their common defense. Tennessee Constitution was modified in 1834 with greater unease over slavery and came new language limiting the right to white citizens only. However, it was declared unconstitutional. Remember that the Civil War ended May 13, 1865. Written in the local Nashville Dispatch on December 2, 1865, the headline read, "Carry a deadly weapon. Every good citizen is now supposed to carry a deadly weapon, and it's their imperative duty to shoot accurately when attacked by midnight assassins or robbers. A reward should be given to the citizen who kills the first highway robber in or around the city." I do have it noted here that the Nashville Dispatch ran from 1862 to 1866. It was also noticed by anti-federalist Patrick Henry stated, "The great objective is that every man be armed, everyone who is able may have a gun." Then in 1870, after the Civil War, we have Article 1, Section 26 language of today. It reads that the citizens of this state have a right to keep and bear arms for their common defense, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. And here's where it gets interesting. At the constitutional debate leading up to the 1870 language, it was explained by delegate John A. Gardner that the purpose was to deal with the wave of post-war crime and banditry due to the lack of law enforcement. Tennessee citizens could be called together for training and equipment inspections and could be required to provide themselves with the necessary equipment, whether that included firearms or not. This would produce direct results in terms of law enforcement on the streets. It was noted by Gardner that his amendment recommendation, "But the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime," was merely clarifying an already existing power of the legislature, which means 51 votes in the House. If we took that vote, we could sell the lantern off the top of the Capitol. So we already knew that we have the ability here as sitting representatives to do so. Now here's the however, and here's, Mr. Chairman, as we spoke previously, that like I said, I'm not a lawyer, but I keep looking at how does our Constitution read? What is the history of it? And maybe what should it look like 4 years from now? And of course, it's a lot of the federal cases that are coming before us. The recent SCOTUS decision in New York State Rifle and Pistol Club versus Bruin requires that scrutiny regarding the Second and 14th Amendment issues be relegated to historical traditions, quoting from that decision. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules that other Bill of Rights guarantees. McDonald, 56 U.S. at 780, plurality opinion, we know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speeches or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him, and it is not how the Second Amendment works when it comes to public carry for self-defense. The correct period analog of the Second Amendment from our 1796 Constitution does not give power to the General Assembly to deny a civil rights, and at the Second Amendment was enumerated as the right of the people and incorporated against the state in 2010 by SCOTUS in McDonald versus City of Chicago. The legislature has no power to constrain it. So with all of that said, humble members on this committee, I would like to take this bill off notice because I think we need some more discussion on what should Tennessee really be looking at as far as Second Amendment rights within this state. Thank you, Mr. Chairman.
Thank you, Representative Reedy, and appreciate the information today. Without objection, House Joint Resolution 38 be off notice. Members, that's our last item on our calendar today, and seeing no further business before us, we'll be adjourned, subject to call of the chair.